would call your attention to 13 tools that are mentioned in one of the previous lectures. 13 tools of argument. Actually, in this lecture, I want to cover 13 tools of argument briefly, and you can read more about that in the material. First of all, the first tool is that you make inferences and conclusions. You draw inferences and you make conclusions, or draw conclusions from the evidence. Let's take an example. In the fire truck case that we just went over, we know, one of the facts states that we know that the garage was 2 blocks from the office. Because the garage is 2 blocks from the office, therefore we can infer, we can make an inference, or we can conclude that it would take at least a 5-minute walk to get to the office, for the defendant to get to the office, and that the defendant knew how long it would take him to get to the office. So again, an inference must be based upon fact, but it is a logical conclusion that we draw from an existing or a known accepted fact. So again, that's the first tool that you'll have, is to make inferences and to draw conclusions. The second tool you have is to cluster circumstantial evidence and accumulate details. And again, this is the point of the trial when you will want to cluster different facts together. You'll want to decide these facts belong together, and we're going to present them together as a cluster or as a group. I used to collect coins when I was a little boy, monety. I loved coins. I used to collect coins. Different people like to collect different things. We had a case here in Utah just a couple of years ago where a man was arrested at his home for a criminal matter, and when the police arrested the man, they found that he collected beer cans. The word is banok piva. He had 70,000 beer cans in his apartment. He had so many beer cans, 70,000, 70,000 beer cans, or banok piva. 70,000 beer cans in his office, or in his apartment. Well, we don't want you to collect banok piva, but we want you to collect or cluster facts, cluster evidence. For example, in a closing argument in the firefighter case, the plaintiff's attorney might cluster these facts together. The attorney might say, ladies and gentlemen of the jury, let's look at the details. Let's look at the distance to the office. The fact that the defendant had a meeting at 8:30. He knew that he had to go 2 blocks to get to his office. He knew that he was late. He knew that he would not be able to find a parking spot. And he made a cell phone call immediately after the crash. Those are facts that if you cluster them together, they gain strength. A group of facts, of related facts, are much stronger than one single fact. The other thing I want to point out is that it is not necessary in closing argument that you go strictly by timeline. You are permitted to pick the facts that support your case and to present them together regardless of the chronology or regardless of when they occurred. In other words, using the example of the playing cards, an attorney who is not effective in closing may simply present all of the facts chronologically. Ladies and gentlemen of the jury, we have this fact. Let's say this is a defense attorney's argument. We have this fact is strong for me, this fact is strong, then this fact is not very good, then this fact. That is not a good technique. You do not want to go chronologically in presenting your closing argument. You may want to go chronologically, but you do not have to. You have the power and the ability to cluster and to join together the facts that are strong for your case. Another Another tool that you have in closing argument is to use analogies and stories, to tell stories. This is, again, is a time that the attorney presenting the closing argument has to relate to the jury, to become a human being to the jury. We do that by telling stories. We as human beings, we respond to stories. We love stories. We're interested in people. We love hearing about people. An analogy, an example of an analogy would be, in the firefighting case, would be something like this. Ladies and gentlemen of the jury, the defendant was in a hurry that day, and he was playing Russian roulette with the lives of other drivers on the street. Now, that's an example of an analogy. An analogy is when you compare it to something else, playing Russian roulette. You may also make allusions. These are analogies or comparisons that relate to commonly known facts or to popular culture, to movies, to fairy tales, to stories, to legends. For example, in the firefighter case, the defendant may want to make an analogy such as the following. He could be pointing out that the plaintiff had been camping for a period of 4 days and had slept on the ground. He could say something like, ladies and gentlemen of the jury, the defendant was like the princess in the story, The Princess and the Pea. Now she feels it. Okay, there's an example of an analogy. That's not a very good example, but you get the idea. Another very effective tool that the attorney can use in closing argument is to tell a story. And in fact, can tell the story of the plaintiff or the defendant. For example, in the firefighter case, the plaintiff's attorney could tell a story such as this. Ladies and gentlemen of the jury, let's try and imagine what the defendant's day was like. The defendant awoke late, was driving to work, was behind schedule, had an important meeting, a meeting that was important for his business. And to make matters worse, traffic was heavy and there was no parking space near his office and so on. So you could tell a story in such a way that the jury could relate to it. Another tool that you have, this is the fourth tool of argument that you could use, would be to emphasize undisputed facts. Those are facts that no one is arguing about, no one is disputing. And you could say, for example, members of the jury, it is undisputed that my client, the plaintiff, was rear-ended on that day by the defendant's car. It is undisputed that he was late for an appointment. It is undisputed also that he made a phone call to his office immediately after the accident. So in other words, you use, by stating the undisputed facts, you're giving strength and continuity to your case. You can also refute opposing witness testimony. For example, in the firefighter case, the plaintiff could state, the defense claims that he was not distracted, but ladies and gentlemen, let's look at the facts.